Hi, my name is John Fazio. If you're watching this video, then you are interested in learning more about the foreclosure litigation timeline. That's all the time from the time when you get served with a summons and complaint all the way until, in theory, you would go up for auction and have your house go to sheriff's sale. So to put a finer point on this, I'm going to try to give you guys a little whiteboard session that kind of goes through what goes on in a foreclosure litigation. So here you have the bank, who's the plaintiff, and you, the defendant. There's going to be a couple stages of this litigation. The most important part here is the beginning. These are the pleadings. There's going to be a complaint, and then you have 35 days to file your answer and counterclaims. Very important. Then there's a discovery process where you can get information about the balance on your loan and things of that nature. So there's going to be notice to produce, ROGs, which are questions that you ask each other, RFAs, which is where each side asks the other to admit things, and depositions. This can be from 3 to 4 months. Next stage is summary judgment. Summary judgment is basically a trial by paper. So in a summary judgment motion, anything that somebody would testify to in court, any evidence, is going to be submitted like a term paper. And with exhibits, which is the evidence, and affidavits, which is in lieu of live testimony. This takes 3 to 4 months. Then there's going to be a default and entry of judgment. This is going to take, about 2 months. This is an entry of the judgment to foreclose, not the actual financial number. So you're going to contest this. There's a 14/45 day cure letter, which is going to cause this to be about 2 months. Then there's a motion for final judgment. This is 1 to 2 months before the. Now this can be longer if you have some significant items that you want the bank to look at. Then you got final judgment. This is when they have a judgment for the amount that the bank is owed. Well, this can be longer too, but we'll say 1 to 2 months. Okay, this is where the rubber meets the road. They can apply for a writ. Then sheriff's sale scheduled. So this takes 1 to 2 months. Sheriff's sale is going to be scheduled 1 to 2 months. You have adjournments, and that's 2 months. Okay? So this whole process is 6 to 18 months. And if you don't answer the complaint and you get defaulted, then all this time, whereas you go through all these steps, right, is gone. And you go all the way down to here. So you miss out on potentially 10 months or more of time when you could be fighting the case. So this is the diagram here of the timeline, and I've got another pictorial representation of it. So if you're in a foreclosure and you're questioning what to do, what you need to know is that you really want to file an answer to that foreclosure, and you want to get the maximum amount of time that you can, because when you have time from that timeline that we just went through, it's time for you to do the loss mitigation steps that you want to do. It's time for you to explore what the bank is actually owed. It's time for you to contest the bank's proofs and put them back on their heels and give them some questions about what the ultimate result is going to be. You could have your own claims that you want to bring up. You could have things like material misrepresentations that they made throughout the servicing of the loan, about the balances, about forced placed insurance, things like that. It could be predatory lending when you first got the loan. It could be modification fraud by the servicer where they haven't complied with 12 CFR 102441. Now, again, this is a little more technical, but another thing that happens during the course of this timeline is there's a parallel dual track with the loss mitigation. And under Dodd-Frank, under 12 CFR 102441, you have the ability to expand the time before they can file the complaint. Or if the complaint's already filed, you can expand the time before they're allowed to move to go to a sheriff's sale and take the final action in your foreclosure case. Because they have to review you, Congress has determined, for all loss mitigation options and complete that review, which has several steps and parameters before they can go to the ultimate remedy of resorting to taking back and repossessing your property to pay off the debts that are attached to your property. So if you are in a foreclosure situation where you've been served with a summons and complaint, I would recommend to you that it's very important for you to utilize the process that the courts have put in place to your best advantage to gain the time that you need to find a solution to the problem, and in order that you can simultaneously get the best possible result, and that you can eliminate and explore each option as you go along until you find what works for you. If you have any questions at all, please give us a call at 201-529-8024. We'd love to help you get out of this difficult situation once and for all, and to work with you to go through and the foreclosure litigation timeline, and to advocate for you at each step along the way. Look forward to speaking with you. If you have any questions, please feel free to put them in the comments. Fill out one of our web forms, go to our website, or reach out to us any way that you would like. I would love it if some people would engage and put some questions in the comments below, and or send me an email and contact me directly. Thank you so much. Bye-bye.